Hi, welcome to our program today, Discussions on Democracy. I'm Elaine Englehardt from Utah Valley University. This series is sponsored by the Center for the Study of Ethics. Today, our discussion is on the Utah State Supreme Court and the function of the court in a democratic society. And we're so honored to have the Chief Justice of the Utah Supreme Court with us today, Christine Durham. And Your Honor, would you mind telling us a little bit about yourself, your background, and what it's like to be the Chief Justice?
I'd be happy to, just briefly. I began my judicial career a number of years ago on the trial court and then went on the state Supreme Court in 1982. I've been Chief Justice of that court since 2002, and one of the functions of the Chief Justice of the Supreme Court of Utah is to head the Judicial Council and essentially be the chief executive officer of the state judiciary. So in my work on the court, one of the things that we're responsible for are promulgating standards of conduct for lawyers and for judges, the canons of ethics. And then in connection with my work on the Judicial Council, I'm also responsible for the administrative side of the state courts. So the job is really extremely varied. I have loved everything I've done, and I'm delighted to be able to talk about these subjects of interest today.
Next, we'd like to introduce Jill Jasperson, who is our Associate Director of the Center for the Study of Ethics. And would you tell us a little bit about yourself, Jill?
Sure, thank you, Elaine. My name's Jill Jasperson. I've been here at UVU since 1997. I'm a professor, associate professor of legal studies here, and presently I'm teaching legal ethics. So that will be a good topic, and also I'm teaching business law. In fact, I have some questions from my business law students that they want to ask you.
Dr. Keller, we have David Keller with us today, who is the Director of the Center for the Study of Ethics. Would you tell us a little bit about yourself?
My name is David Keller, and I've been at UVSC, now UVU, since 1996. I'm professor of philosophy. As Elaine said, I'm director of the Center for the Study of Ethics, and I'm also the director of the Utah Democracy Project, which is hosting this show.
Great, thank you. Well, Justice Durham, I was mentioning to you that I'm a member of the Judicial Conduct Commission for the state of Utah and enjoy that very much. And we're often looking at the 5 ethical canons of the judiciary. And do you mind telling us a little bit about the importance of these, and then we can even get into some specifics?
Well, the bedrock of our American legal system is the notion that we have an independent judiciary, that the courts provide a forum where people can come to get a fair and impartial resolution of the disputes that they have between themselves as private citizens or that private citizens have with their government. Absent an independent judiciary, most people believe that the rule of law as we understand it and as we enjoy it as Americans would not be possible. And there's one theory that the canons of ethics for judges, the Code of Judicial Conduct, has built into it all the precepts that are necessary to preserve the independence of the courts. Part of that is accountability, the notion that judges can be seen in all of their conduct to live the kinds of lives and do the kind of work that the people will understand as being fair and impartial. And the other part of that is that it also has an interface or meshes with the codes of conduct for lawyers. I can give one example. Judges are required to avoid any form of ex parte communication under the canons of judicial ethics. You probably see some complaints related to that. And ex parte communication is where someone who is outside the case in front of the court actually tries to communicate with the judge, or the judge permits such communication, or even in some cases the judge could wrongfully initiate such a conversation. Well, what's wrong with that, of course, is that it raises the possibility that the judge will be unfairly influenced by something that the parties in the case may know nothing about, or that one party in the case may know about, but the other side won't know about. So that rule, it's a rule of judicial conduct and a rule of lawyer conduct, but it exists to ensure and preserve the judge's impartiality and independence. So the first canon deals with independence and integrity, and in some respects, all of the others, I think, are designed to ensure that that one is successful.
It's a very important point philosophically, something that Dr. Keller would be talking to his students about in his ethics classes, and I'm sure professionally. Jill, what are some of the things that you talk about with your students when you're discussing integrity and the judiciary maintaining this autonomy?
Well, we just talked today, in fact, about attorney-client privilege and how important that is, and the broader scope of confidentiality, and how important that is for attorneys to keep that. I think that's an important thing, and it's very ethical. We talked actually last time about the case where the attorney knew about a body, a dead body, and he could not disclose where it was under his attorney-client privilege and confidentiality. And the students were very upset about that. They didn't know, there was this ethical bind between the two. So, yeah, it was a hard thing.
And there are, of course, very limited exceptions to the rule of confidentiality. For example, if an attorney knows about the imminent commission of a crime that will cause injury or bodily harm to someone, he or she can breach confidentiality. But that particular standard of conduct for lawyers is perhaps the most difficult for lay people to understand, because what you have to do is step back 2 or 3 layers to understand that the purpose of the confidentiality requirement is to permit the adversary system to function. Mm-hmm. If you've got fair and impartial judges, it's not going to do any good if you've got lawyers who are in a position, who are disclosing information that came from their clients without the permission of those clients. That lawyer-client relationship has to be sacrosanct in the same way that we protect the relationships between penitents and clergymen, clergy people, and the way in which we protect the relationship between patients and physicians. Our notion is that the work that is done by the clergy, is done by physicians, and is done by lawyers cannot be done effectively if the people who come to them for advice and help cannot rest assured that nothing they disclose in that relationship can be disclosed more widely without their permission.
With reference to the canons that you were just talking about, you mentioned the importance of impartiality and independence. The Center for the Study of Ethics has had Senator Orrin Hatch on campus several times, and more than once he has remarked on the worry of activist judges setting public policy rather than enforcing the rule of law. To what extent is there a worry about activist judges in the sense that Senator Hatch is speaking, and to what extent is it political hyperbole?
The notion, for example, that an activist judge is one who, quote, makes social policy as opposed to interpreting the law, is a very elusive notion. I mean, you may be dealing with language in a statute. Mm-hmm. Your job as a judge in doing statutory construction is to try to figure out what the legislature meant. Well, if it was crystal clear what they meant, you wouldn't have the lawsuit. So judges are required to account for legislative intent. Whatever decision they make is going to have an impact on policy, because that's what the statute was addressing in the first place in most instances is policy. My own concern is that as I see people talk about activist judges, and it's a label that's been attributed to both judges appointed by conservative presidents who would be seen as conservative politically, mm-hmm. as well as to people appointed by liberal presidents who would be seen as liberal politically. My own sense is that frequently the definition of an activist judge is one who has made a decision with which you disagree.
That's the impression that I got as well.
Because I have a very hard time with it. It's a particularly difficult question for judges who, like me, serve on state courts, because state courts, unlike the federal courts, are common law courts. And we continue to have lawmaking responsibility for the development of the common law. And the common law, of course, is the law of contracts, the law of property, the law of personal injury and torts, huge areas of the law where the legislature may act, but in the absence of legislative action, we actually make the rules in those areas of law. So, of course, we're deciding questions of policy. And of course, policy has to enter into our deliberations. Now, in theory, the federal judges are judges of limited jurisdiction. They, in theory, don't have common law practice, but there are these huge gaps in the statutory law and, of course, in the area of constitutional law, where you're constantly trying to fill in the interpretive spaces, and there's no question that the decisions have an impact on policy. I do think that it's improper for judges to make their decisions based on their personal policy preferences. But to sort that out when they're doing the interpretive work with statutes and constitutional language can be very difficult indeed.
There's an art to interpretation, and that's what you do.
Yes.
Recently, U.S. Supreme Court Justice Anton Scalia at Utah State University remarked that he viewed the Constitution as static. And in philosophy, we tend to think of documents as being fluid insofar as the meaning requires interpretation, and the interpretation might change with social conditions and cultural conditions. And so, I tend to think of documents as not being static in the way that Justice Scalia thinks of the Constitution. Is it possible for the Constitution to be a static document and for justices such as yourself to come up with objective, true interpretations that don't have some subjective element?
Yeah. I don't share Justice Scalia's view of the federal Constitution or of the nature of constitutional law in the United States. And one of the reasons I do not share it is that it seems to me that it's a notion that would so greatly hobble our ability to rely on these foundational documents like the federal Constitution to inform our lives as 21st century citizens and to help us sort out the allocation of duties, responsibilities, and rights that the Constitution is responsible for. I'm interested, for example, the court recently issued a case interpreting the Second Amendment to extend to the right to bear personal arms, I suppose anything from a Saturday night special to an AK-47, although the details of the implications of that ruling have yet to be worked out. Right. In some ways, it seems to me, if you were going to go totally with original intention, you would have had to say the Second Amendment applied only to the arms which existed at the time the language was written.
And
muskets
right.
and so on. Yeah. So I have a hard time understanding exactly what the boundaries of that notion are, and I think I would, in any event, draw them in a different place than Justice Scalia does. And I also think that even he and those who have studied and written about his jurisprudence have noted the occasions on which he's not been able to be faithful wholly to his notion of originalism in the Constitution, because there is a sense in which the framers never contemplated the questions that today's courts have to answer.
Right.
But they clearly contemplated, I believe, that the document they framed, that has now seen us through hundreds of years, would serve to see us through the questions we brought to it.
Well, Jill, do you have a question from one of your students?
I do.
That happen to be taking legal ethics this semester?
Yes. Actually, have you ever decided something against your own personal ethics?
That is a very difficult question to answer. and part of the reason it's difficult to answer is that it really is so very rare that the questions which come before me as a judge and come before our court have anything to do with my personal ethics or with me.
Yeah.
I mean, so for example, there are societal institutions, there are events in public life about which I have personal views, or in some cases, I observe human behavior that's not consistent with my personal standards of behavior and what I would consider to be ethical behavior. But in some respects, it's none of my business whether someone else's behavior violates my personal standards, what is my business is to determine whether their behavior violates the standards of criminality or meets the standards for civil liability or is consistent with the fundamental guarantees that individuals have in our society to carry out their lives. So I haven't answered your question, have I? For example, I have grave concerns about issues having to do with the family. I have grave concerns about issues having to do with things like capital punishment. But I do not see my concerns as relevant to my job to understand and enforce the law as it has been written, or to help in the area of the common law to move the law ahead in ways that are consistent with public policy and individual and human rights. So I guess the answer probably is no.
Okay.
I mean, I've had to make decisions where I found the results of the decision distasteful on personal grounds.
I was going to ask you that. Do you have some decisions that have kept you awake at night? Is what they asked.
Many of those. Many of those. We get a lot of hard cases.
I have a case to ask you about, and it's not one of yours. It's the 2000 Florida election case, and wondered
Bush
if
v.
you
Gore.
wondered if you could tell us about the Supreme Court making the final decision on this election. Was it the right place for this final?
Let me begin with the caveat that I'm not an expert on federal election law, nor am I an expert on Bush v. Gore, and the case has generated an entire industry of commentary
Yes.
and literature. But one of the significant problems, I suppose the bottom line is that I am not uncomfortable in the end where a constitutional question is raised with the notion that courts will be the arbiters of the final result. However, what happened in the 2000 election and what happened in the litigation surrounding the 2000 election was very unusual procedurally. And one of the things that did offend me about the case is that federal election law, that there are rules appertaining to federal election law for which Congress is responsible, but the actual maintaining and running of elections is a matter of state law. And that's what was at issue in Bush v. Gore. How were the votes to be counted? What were the procedures that were legitimate, et cetera, et cetera. And perhaps as a state judge, I'm showing my bias, but I found it distressing that the United States Supreme Court, which gives lip service to federalism and to states' rights on many occasions, on this occasion, took the decision away from the state courts on a question of state law and decided the case. So there were federalism issues as well as separation of powers issues. But the bottom line is, one of the most remarkable things, and some people talk about what does Bush v. Gore mean for our democracy. I think the bottom line, however distressing any given part and or the result might be to an individual, the remarkable thing about Bush v. Gore is that nobody went to war over it. Not a shot was fired. The American people accepted a final determination. We groused about it, a good many of us, but we were able to put the pieces back together, and the loser in the election was able to accept the verdict. So there's a degree of legitimacy that we afford to process that enables us to survive as a nation. And I'm in favor of that, although I do think that there are occasions when it gets very threadbare, that legitimacy. And the courts in particular need to be careful because we have nothing but that acceptance of our legitimacy to keep us in business. And if we ever lose that, no purse, no sword, if we lose that, the system could significantly fail.
David, we have a philosopher, Thomas Hobbes, early writing in the 1500s, who's saying that a judge must always judge fairly between parties. There can't ever be a sense of impropriety or unfairness, or it can lead to war, to shots being fired, because That's how they talked about it then. Can you tell us a little bit about philosophically why this notion is important, a judge avoiding impropriety?
Well, I think that Hobbes talked about the importance of the sovereign and the sovereign in adjudicating conflicts between different parties, and the rule of the sovereign and the body politic must be respected to avoid war. And Bush v. Gore seems like an example where the resiliency of our democracy was tested perhaps almost to its limit. And in my ethics and values course just the other day, we had an entire discussion about the partisanship and sort of the polarization in the American public over a broad range of issues. But whether you're, from the right or from the left or conservative or liberal or moderate, one testament to the last 8 years has been the resilience of the American people to at least discuss as civilly as possible our differences without getting violent. In many nations around the world, that would have not occurred. So I think that everyone probably thinks they live in the most interesting time in history, but for me, the last decade or so just seems like there have been many monumental points in history that we've gone past, and it's an exciting time to live, but also distressful.
Yeah, I think you're well known as a Chief Justice for education. And in fact, just recently you were talking about civics education. I think that's probably one of your pet projects. Or can you tell us a little bit more about that? I'd love to hear about that.
Well, that question actually dovetails, I think, really well with what Professor Keller was just talking about in terms of the resiliency of American democracy. That resilience will end the day there ceases to be a new generation prepared to shoulder its responsibilities and who understands the costs that have to be paid for its maintenance. When I have done a little bit of research in the early history of state constitutions and public education, it's absolutely clear that some of the original founders and almost all of the founders in the state context viewed the necessity of public education to be directly tied to the necessity of training future citizens. And I have grave concerns that with the multiplicity of demands that have emerged, over the last century, for example, in public education, I mean, there's so much more. You used to be able to educate children to be literate and to do basic math and hopefully some exposure to the classics and foreign languages. Now, the scope of human knowledge that we have to expose them to and the skills and competency they need to survive is vast indeed. But partly as a consequence of that, we have in the last 30 plus years lost sight of that foundational mission of public education to prepare young people for citizenship. And actually you may be right about the resilience. One of the most hopeful things about this political season for me is the research suggesting that young people are engaged with this federal election in particular, and that they are, we hope, we'll see after Election Day rolls by, that they understand that their vote is important, that their engagement with the issues is important. But I feel very strongly that the degree of alienation, of opting out, of civic disengagement that we've been noting for a couple of decades now in college students, high school students, and young adults, and the research suggests, by the way, that your patterns of political engagement are pretty well set in college, that if you get through college without any sense of obligation to your community to engage with it, you'll probably spend most of the rest of your life that way. And that's a really distressing possibility. So that's why I care about it. I care about it also from the vantage point of the third branch of government, which is the least understood. The the most misunderstood. And so I have a little bit of a vested interest in civic education that helps young people in particular, although all of us need reminders of the ways in which the branches of government should interact and the parts that they all have to play in keeping us free.
So are you thinking about, would you like to see more civics?
Yes.
What I mean,
Well,
how to go
one
about
thing-
doing that, I guess. How should
well,
we do it?
Therein lies the rub. A couple of things that have happened here in Utah that are very helpful, one of which is that 4 or 5 years ago, and it just got rolled out, I think 2 years ago now, the Board of Education put back into the curriculum a mandatory course on civics. The other thing that's happened is that we've really come to understand the whole nature of pedagogy and teaching and learning about civics, as well as other things, in a new way. Some of us, I think, are old enough to remember the 8th grade, how does a law become a law? That's not going to do it. Now we engage students in mock trials. We send them up to the legislature to follow state legislation around. We send them to city council meetings. We have learned that young people will get turned on by this work and come to understand it if they're given the proper experiences. So, but the mandatory requirement's pretty good. The number of people in every survey who don't know the difference between federal and state courts, who don't necessarily understand the difference between the federal and state government, who don't know who their local leaders are, who don't know what's in the Constitution. You know these studies. Parade Magazine had one a couple of years ago where they sent people to the Declaration of Independence, and more than half the people dismissed it as a liberal, radical tract. We don't know our history, and we need to get back to that. There are other things going on. I am currently, I chair the Coalition on Civic Character and Service Learning, which is an umbrella agency that involves over 30 different organizations, including We the People and Law-Related Education and so on, that all of these people are doing wonderful programs on civic education. And the legislature, 3 years ago, actually funded the creation of a commission on civic and character learning that the lieutenant governor heads. And that commission, and I sit on that as well, that commission is undertaking voter education for high school students and some mock election activities. Voter registration is huge. Again, one of the best things we could do, I think, would be to get mandatory voter registration programming into every 12th grade in the state. And get students, again, get them inculcated with those values early. You can see you touched a nerve on that one.
I see.
Well,
Yeah, that's
actually, the reason we have Justice Durham on campus is to give her our Excellence in Ethics Award. And one of the major reasons are your attitudes towards making sure that we do have a well-educated democracy and that they understand the courts, that they understand the election process, but also the things that you've done as the Chief Justice of the Supreme Court. You might be interested to know that here at Utah Valley University, we have a unique element of our education. Our students have a required course in ethics that they need to take before
Professor
they graduate.
Keller was telling me that. I think it's terrific. That's wonderful. I mean, it's not that they will learn how to answer all the questions, but they will learn to recognize the questions and get some tools for discussing the questions and thinking about the questions.
That's right, and because it's a general education course, naturally the students complain about it ad nauseum, but what we all agree on once we're in the classroom is that a democracy cannot function unless each citizen takes the responsibility upon his shoulders or her shoulders, and that when we gave up the aristocratic form of government, we took upon ourselves a huge burden of responsibility, and apathy and disengagement sets us up for failure.
Well, and they can be seen as a form of unethical behavior as a citizen.
One point that you make in the Salt Lake Tribune op-ed that Jill referred to, and this struck a nerve with me because I complain about special interests and money in politics, and you say you twist it in such a way that you put the responsibility back on us as citizens to make sure that all the vacant spaces in the body and in the political process are taken up, and that when we disengage ourselves, then we create the spaces for special interests to come in. So I thought to myself, rather than complain about it, David, what you need to do is, sit on, the neighborhood council or get more engaged.
Write more letters to your legislator.
Write more letters to the legislature, but in a sense, we bear the burden of responsibility for allowing special interests to come in and fill up those vacant spaces.
There is a sense in which that's true. Too many of us do complain about others having too much influence without ourselves even making an effort to exert influence.
One of those controversial areas in Utah where sometimes folks feel like there's too much influence might be guns, and guns on college campuses. And I just wondered, what did the courts learn from the gun ban at the University of Utah and working through that?
Well, the University of Utah's gun ban was in fact litigated in the state courts. Interestingly, the question before us, once again, was not the effectiveness or rightness of a policy of banning guns or having guns on campus. That's an area in which my personal views were irrelevant to the question we were asked to decide. The question we were asked to decide was whether or not the University of Utah, under the language in the state constitution, had the autonomy and the independence to make that decision for itself. And there were really two questions. One was whether the University of Utah, and actually that part of the case would not, even if it had come out the other way, still wouldn't have had any impact on UVU, for example, because the University of Utah is in the state constitution in a way in which the other institutions are not. But then the other part of the question was the one about academic freedom. And academic freedom, of course, would apply in any university setting. And a majority of the court ultimately determined that academic freedom was insufficient. The historical roots of that, and they are largely common law roots, were insufficiently strong to insulate the University of Utah from a direct legislative policy enacted in statute. And that was the decision of the court. I dissented in that case on the constitutional grounds, not on the academic freedom grounds, because the majority of the court also decided that the University of Utah did not have sufficient constitutional independence historically to enact that. The thing I was very concerned about, and it was connected to academic freedom, is that frankly, on the basis of the rationale in that decision, I find it hard to identify any decision that a university might wish to make in terms of policy that the legislature couldn't override. And that to me is a very disturbing set of affairs for a public university, because the business of universities is not the business of the state. I mean, it is in a sense, and the university belongs to the state. Public universities belong to the state. So in some respects, we weren't deciding guns. We were deciding constitutional language and academic freedom.
Also, the media always turns it a little bit, and what you were just talking about probably wasn't reported at all.
Well, I know, and
in the media,
that's a problem for us appellate judges especially, although trial judges too. What we do is often very nuanced. And
you're right. You're right.
It's difficult, and we have a real problem with public education about the work of the courts, in that it is so dependent, at least for individual cases, it's so dependent on the media who covers the decision-making process and results. And frankly, the way, particularly the print media and the broadcast media have all been going, and of course the rise of this whole new media, the blogosphere and internet coverage, you get very little expertise building up in the local press about the nuances
There's not a lot of nuggets there.
That's right, of constitutional law. It's hard stuff. I mean, ideally, you'd have people who were law trained, or at least who had been covering the courts for years with a lot of specialized training. But you don't in our local court. You do at the Wall Street Journal and the New York Times and at the U.S. Supreme Court level. Actually, we get some really fine commentary both in the print media and so on at the U.S. Supreme Court level. But in our state, you have reporters who may have been there for 6 months, and 6 months ago they were on health care, and 6 months from now they may be doing,
who knows?
Yeah.
Or maybe the society page or whatever, yeah.
So I guess if I had any message for your students, it's read the paper and think about it, but don't believe everything you read in it.
I do, yeah.
You know, back to the issue of the necessity of education in a democracy, and you may or may not have the kind of opinion on this that I do, being a college professor, but it seems over the last, decade or 2 decades, there has been a corporate model that has crept into the system of higher education, where it's perceived more and more that our job is to train students to get out and get a job and earn money, and more of an emphasis on technical training and economics rather than civics and citizenship. And it's almost as if citizenship can be absorbed by osmosis from one's friends and family, but it really isn't our role to get into the messy normative stuff of ethics and policy analysis and talking about nuanced issues. What is the role of public education in a democracy, and is there a danger that we become too focused on economics?
Oh, absolutely there's a danger. It isn't a new debate, though. The content, quality, and purpose of a liberal arts education has been the subject of debate in the academy and outside the academy for decades, perhaps centuries. Although it may be more acute in challenging economic times.
Yeah.
And the fundamental question is our job in the university to prepare students to get a job, or is our job to help them learn how to think better? And I'm the product of a wonderful liberal arts education. And I had the privilege of having children who had that opportunity and the interest and ability to use it. And so that's where my bias is. I think you can master the technical skills, and indeed, some of it, it's interesting because some of it, I think, some of the current pressures come from the increasing focus on accountability and measuring success. And it's so hard to find measurable outcomes. How do you measure whether a student thinks better at the end of 4 years of undergraduate education? Certainly you can look at things like, do they vote? Do they go on to be engaged citizens in terms of but it can be things like reading the newspaper and going to their homeowners association meeting and things that are very difficult to measure, whereas placement statistics and median salaries, you can get your arms around those quite readily. But I think those of us who champion the cause, the value, and in fact the essential nature of a liberal arts education have to stay in there fighting. I really do.
As you were speaking, it occurred to me that measuring qualities is difficult and outcomes, and this kind of emphasis on are we as educators performing as we should, and we want to see some hard data to back it up. It's hard to measure that, but also the true outcome may not come at the end of the semester.
Precisely.
I was just thinking of a former student here who came from humble surroundings here in Utah County, went to UVSC, and went on to go to the Kennedy School of Government, and is now in Texas doing a doctorate in public policy at the University of Texas at Austin.
Wow.
But this is a 6-8 year process, so I would say that we had good outcomes with regard to this one student, but it took quite a while.
Not going to help with your budget discussions
No,
and in your departmental
no,
meetings.
No. Or going to Capitol Hill and saying, this is why you should fund us because we're doing our job well.
And because of the importance of being a well-educated person.
Yeah.
And that seems to fall on deaf ears. But when you say, well, we can give you students who can think well, speak well, who can move from job to job with ease because they have been taught to be good critical thinkers and good writers and good speakers.
People who believe in that mission. And frankly, the biggest champions are in the academy and the academicians themselves. You just have to keep making that case. But my father-in-law was a university president, and I was very close to him, and as was my husband, and spent many years during his service and thereafter. In fact, he was the first commissioner of higher education for the state of Utah when the Board of Regents was created and higher education got its own independent stature. And Homer Durham.
Oh, what a wonderful
yeah,
man.
so he was a wonderful mentor to me in
Yes.
helping me think about the value of liberal arts education, but the scope of education as well. He was always a great champion for the notion that students should be in a position to get what they need, given their circumstances, their hopes and desires, and their potential. And that can be different from student to student as well.
We just need more Homer Durhams.
It would be, yeah.
Yes, he left an amazing legacy for us.
He really did.
Can I ask you kind of a juicy question about what judges just can't do, whether it's you or other judges, and how close you can come to a fine line? I mean, can you go in a bar, or can you?
Yes, judges can go into bars. And actually, that's a very interesting question. What judges, of course, there's what judges should say and what they can't say. But the canons require them to conduct themselves with a demeanor that will not bring disrepute on the judicial office. So going into a bar is fine, but getting drunk, falling down drunk in the bar, or leaving the bar and getting into a car after having imbibed are not fine. Of course, the latter is criminal as well. But both of those, I think, would be a violation of the canons of ethics, because both of those actions would bring disrepute on the judicial office and undermine the confidence of the people in the integrity of the judiciary. The other kinds of things judges cannot do, and again, I suggested that they go to the canons in some ways exist to shore up judicial independence. And one of the things that judges cannot do is to speak out and commit themselves to the results in certain types of cases. This is more of a problem in jurisdictions, unlike Utah, where judges actually participate in public elections for their office and have to run campaigns and so on. And of course, that goes to impartiality as well. How do you feel if you're a company litigating a question having to do with the interpretation of the statutes relating to oil, gas, and mining, if you've had a judge who's announced, here's what I think about drilling for oil shale, et cetera. So judges stay away from that kind of thing. In Utah, we are apartisan. Again, that varies from state to state. And that means that we may not attend any kind of partisan-related activity. We can't go to fundraisers for the Democrats or the Republicans. We can't. It raises some interesting problems when the Republican Party in Utah several years ago required a closed primary so that you had to declare yourself and go on record as a Republican in order to participate in the primary. There was some question as to whether it would be proper for judges to vote in the primary. Now there you had to balance the judge's fundamental right to exercise the political vote with the canon that said no partisan activity. And in the end, our ethics committee, our internal ethics committee, looked at it and came down in favor of judges being allowed to vote. But some judges made the individual decision that they thought it would be improper for them, even though it was not deemed a violation of the canon.
lot of what you said would be applicable to any profession. The doctors and lawyers and judges and professors would also be expected to provide a reasonably good role model and not disgrace, otherwise, I mean, part of being a professional is that people have confidence in your abilities, and that if you're publicly intoxicated, that confidence may be eroded.
And given that the essence of judging is fairness, and that's what people expect, you really do have a pretty high standard of behavior for judges. We talked earlier about the ex parte communication rule that prohibits judges from talking to anybody about the case. The announce clause of the canons, which says you can't announce your position on a matter which is likely to come before the court. There are other rules. For example, judges may not sit on cases in which either litigants or lawyers are closely connected to them, relatives within the third degree of consanguinity, on which I've become an expert since I've been a judge, or close personal friends. There are two types of disqualification rules. One are formula. If one of your relatives within that degree of closeness is a partner in a law firm or appearing on a case, you are automatically disqualified. On the other hand, if your best friend is appearing on the case, well, if it's really your best friend, you're probably going to be required to disqualify because you'd be biased. But sometimes it's an acquaintance, or I happen to have a lot of relatives who have the same last name, but they're very distant. And so I don't recuse on their cases because I don't have any daily or even frequent. There's no reason why I would be biased in their favor or against them because of the relationship. So those kinds of rules are designed to shore up impartiality.
And when they're broken, then there is an avenue for citizen
That's
complaint.
something you know about.
Yes, with the Judicial Conduct Commission. And do you want to tell us a little bit about why it was formed and why it's important that people be able to have a voice if there is misconduct?
The Judicial Conduct Commission, on which you now serve, has a long history in the state of Utah. It's been in existence for as long as I can remember. It is unlike in many states, the responsibility for judicial conduct review exists within the judiciary. And many people think that that's the case in Utah, but it isn't. Our commission has independent constitutional status. It has an independent staff. It is funded directly by the legislature, and it exists pursuant to legislative statute. So, and in fact, it's only been, I think, the first judge, the statute was modified to permit a judge to sit on the commission for the first time only about 15 years ago.
Is that right?
Which I always thought was really odd. And that did disturb me a little bit because it's good to have lay people there. It's good to have lawyers there. But every once in a while, it's helpful, I think, for somebody who does the job to be able to explain its circumstances. I would expect that you depend on the judges on the commission, or the, do you have one now or two?
We have two.
An appellate judge and a trial judge.
We do.
And do you look to them from time to time to tell you what the context of a problem is?
Absolutely. We will specifically, there will be specific cases where we will say, was this acceptable behavior? Was this acceptable speech, as you mentioned? What would happen in your own courtroom? And I even had a question about dress, that someone said that they weren't dressed appropriately. The judge had said they weren't dressed appropriately, and I wondered, well, how would you have responded to that style of dress? And it turned out that it was inappropriate dress. I hadn't realized that.
Now, judges do have a lot of discretion, and the language of the canons is, in some respects, deliberately vague. I mean, it talks about impropriety or the appearance of impropriety. And that's, you can be sanctioned for violating that standard. And yet, I suspect as you apply that standard, you don't have too many cases that are really hard.
No,
that,
we don't.
that behavior falls pretty logically to one side or another of that line, and it's pretty easy to see, even though the language is general.
Yes, but we do take the complaints very seriously.
Yes.
And
what would you say is the single most common complaint about judges that comes before the commission?
Probably people not liking their rulings, and
Yes,
when they don't like the ruling, then that isn't something for us
Right.
to determine.
No, that's for the appellate system to
Right,
review.
and so and sometimes I think they feel like that we've just really not reviewed what happened, but we have investigators who will go out and they'll interview the clerks of the court. They'll interview people who were in court that day, whether it might be the judge, the attorneys or witnesses or anyone that could give us some kind of sufficient testimony. So it's not something that we just do as a snap judgment and say, well, we just can't find this.
It's hard work. You read a lot of material.
But
I
we
know.
do get complaints on demeanor, and that's where it gets kind of questionable. Where can this judge say, shut up? In
I
court?
wish they wouldn't.
Yeah. Yeah.
I mean, that to me is disrespectful language, and and there are occasions for judges to be firm and stern even, but I don't think there should be occasions for judges to be disrespectful. On the other hand, judges are human, and some of our trial judges, especially at the justice court level, deal with huge calendars, large volumes of cases, difficult cases, difficult people, so mistakes are made. But we work very hard within the judiciary. We have ongoing programs of judicial education. That's another part of education that I've been really interested in over the years and care so much about it. It came in part from my experience as a brand new judge.
Did they just kind of throw the book and say, here?
Literally.
Right.
They handed me a borrowed robe and a case file,
And said, here,
assigned
figure
me
it out.
a court clerk in a courtroom and said, go be a judge. And I thought that was a bad idea.
So from that, did it take you a few years to say, gee, I want to write down stuff and tell the next person? Or was it right then and there, you're like, I've got to start writing this stuff down?
Well, then and there I became concerned, but it's interesting, you to bring about systematic changes in an institution like the judiciary takes a lot of resources. For example, when I was first a judge in Utah, all of the state trial courts were like individual fiefdoms. My courthouse was supplied, my jurors were paid, my bailiffs were provided by the elected county commissioners and county sheriff in that county.
Wow.
The only thing that the state paid for was my salary. So if I wanted to improve jury reform, improve case processing, I had to go to get resources, and someone in the next county over would have to go through the same process. So one of the most remarkable things we were able to achieve in the state judiciary in the mid-1980s was to centralize administration and responsibility and really create the state courts as a system.
Right, because it sounds like there'd be a lot of unethical behavior. You're trying,
Be very
you've got
hard to
more money
monitor
than
it.
me and,
Yeah,
right,
it was
monitoring
very hard to
everything.
monitor. And one of the things that also bears mentioning in terms of the canons of ethics and accountability on the part of judges, and this is a big difference between the state systems generally and the federal system. We have a commission on judicial performance evaluation, which actually conducts surveys and gathers data and information about how judges are performing. It's used for two purposes. One is feedback to the judge herself to know where she needs improvement or he needs improvement. And then the other is feedback and information to the voters when they vote
Now,
in retention elections.
Isn't that a new, this judicial
No, the
performance,
judicial
or
performance evaluation has been going on in Utah for over 15 years, but it has been
what about
done.
the commission or whatever?
Well, it has been done by the Judicial Council
Okay,
for 15
okay.
years. And we developed the standards and we put the process and the survey process into place. What happened last year
Right.
was that the legislature decided to create a commission that was independent of the judiciary to do performance evaluation.
And what do you feel about
So-
that?
Well, there are aspects of that move that were quite disheartening to me. The first was there was no problem. There were
Okay.
no indications that the system that
Was
was in
broken?
place was broken
Okay.
in any way, shape, or form. other than the dissatisfaction of the occasional legislator with an occasional decision by a particular judge. And so it was an interesting thing to me to see that we were doing that work on a very modest budget and had been doing it for years. There were complaints about the adequacy and the format of the data about individual judges that was given to voters.
Okay.
But that was all a function of the lieutenant governor's decisions about how to put the voter information pamphlet back. And a few years ago they told us too much information, we can't get all that information in, so we cut back. And then they said, not enough information, people don't know enough. So nobody ever complained about the quality of the questions asked, the quality of the research done, the integrity of the review process. Nonetheless, inherently, I don't think there's anything wrong with the notion that this would be done by an independent commission. The key, of course, is on the phrase independent. The key is that no one who's disgruntled with an outcome in a particular case will be in a position, or an antipathy to a particular judge, will be in a position from the outside to influence the process of the commission in certifying judges to go on the ballot.
And I think it's also so important to remember we do have 3 branches of government.
Yes.
And that we have the legislative branch, and sometimes they might want to come on over to the judiciary.
Well, historically, that has always been the case. That the legislature, from time immemorial, has wanted to be able to tell judges what to do. But once you permit that, the people will lose. There is no question.
Mm-hmm. Absolutely. I'm glad we have such a strong judiciary in this state. And
well, we're always a pen stroke away.
Highly respected. Highly respected.
Absolutely.
I think Utah's judiciary is well respected. I'm sure you see them because they come
Yes.
from Colin Winchester, who is staff to the Judicial Conduct Commission. The American Judicature Society circulates, I think it's a bi-weekly newsletter on judicial conduct, which
Yes.
summarizes all of the judicial conduct cases from around the country.
that.
Oh, yes.
And that comes to all of us, and it obviously comes to the commission. You read about what happens in other states.
We're a tame state.
We are a very, I like to think of us as a pretty ethical state. Mistakes get made sometimes, and bad behavior happens from time to time. But on the whole, our judges are well trained and follow the rules. They're ethical
Absolutely.
judges.
And I think that was a portion of your work, of what you've been doing. So
Well, it's certainly,
great.
One of the things that's been such a pleasure for me in being able to be Chief Justice for the last 5 years is to work with Utah's governing entity, which is the Utah Judicial Council, which is comprised of judges from every court level. It's got juvenile judges, justice court judges, district court judges, and then appellate judges on it. And that's the body that sets the policy for the state judiciary, governs all the activities like judicial education, governs the budgeting process, sets the budget priorities, and so forth. And you really, when you do that kind of work, you start to get some sense of what it takes, not just decisionally, to have independence, but also institutionally to have
how to
independence.
move it.
To be able to make our own decisions about how the judiciary should be run.
Oh, put perfect closing words. And sadly, we're out of time, but thank you so much for being part of our
You're very
discussions
welcome.
on democracy.
I enjoyed it.
Our
Thank
Chief
you.
Justice, Christine Durham. Thank you.